Hi, everybody. Welcome to the virtual Amicus, and I'm Jay Lodha. Well, the name Zubin Mehta, does that sound a bell? Yes, that famous orchestral conductor. But today, our speaker, who's also an Amicus, shares the same name, but then the field is totally different because he specializes in intellectual property law. He's an advocate by profession, and his name is Mr. Zubin Mehta. And just to give you a brief background about Mr. Zubin, he's a practicing advocate before Honorable Rajasthan High Court Jaipur bench since 2014. He holds a master's degree in intellectual property law from NMIMS Mumbai. He specializes mostly in arbitration, banking, intellectual property, and contractual matters. So thank you so much, Mr. Mehta, for taking out time from your busy schedule for this afternoon at 2 on a Friday. And so the stage is set. The floor is all yours. You may start. Over to you.
Thank you, Jay. I just found that I could invest my time in a little better way on a Friday afternoon. So I've joined in here. I'm going to be presenting today on two topics of intellectual property. There are two very prominent subjects and very less discussed about. So one is geographical indication, and the other is biopiracy. My dissertation was on biopiracy. So basically, what happens is that there are herbs from these jungles, and there are researchers who have actually gone into the forest along with the indigenous people, or who we call as Adivasis. So they go to these forests, take out the herbs from there, they take their knowledge, and then they mass produce these herbs in order to make profits. So which is the wrong thing to do. Now, how do you protect these things? How can you protect something that has been known to people for over generations? And if somebody goes and makes patents out of them, or starts mass producing something that was known for so long, how do you stop that? So basically, that is what biopiracy is. Now, it was introduced in the intellectual property umbrella a long time ago. India became a signatory to this particular treaty, which was called as the Nagoya Protocol. So now under that, we had another act in India that was passed that would actually be beneficial for all the Adivasis or indigenous people as we know them of. So in the future, if anything of that sort happened, so they would get a protection under the Biodiversity Act 2002. So that's about biopiracy. And geographical indication is the most simplest of all. I don't really need to I don't really need to talk much about that, because geographical indication is basically any goods or anything that originates out of a territory which has a reputation or a characteristic which is attributable to that particular geographical region. That is what geographical indication is. So if say suppose there is something that is so peculiar about one particular region, and you can't really get a trademark over it. There can't be one particular person who would say that, this is what I am producing, or this is what I have discovered in this particular region, and I will uh, produce it in my name. That cannot be done. That is not geographical indication. That would come under trademark. But then again, under trademark also, if there's something being produced naturally, or something that has been going for over centuries, one can't get a trademark over there in the same way. The same way, like Sanganeri print, nobody can have a trademark over it. Nobody can have a trademark over Sanganeri print, because that is in the register of geographical indication. Same is with Nagpur orange. Nobody can come up with a name saying, Nagpur orange is being produced in Nagpur, and I will be selling these oranges. Hence, I get a trademark over Nagpur oranges. That also cannot be done. The same is with chicken stitch and the same is with champagne. Now, interestingly, I have got three case laws on geographical indications. So you have your Imperial Tobacco of India versus Registrar of Trademarks, another which is also called as the Shimla mark. Now there is this company who are making matchboxes in the name of Shimla. On their box, they have a logo on which you have mountain peaks covered with snow, and under that it is written Shimla, and they were producing matchboxes. So the trademark registrar uprightly just didn't approve of the trademark. So they had gone to the Delhi, they had gone to the Calcutta High Court. Now the Calcutta High Court also disallowed their appeal, and they came out with a very fine paragraph which said registration of such mark may hamper or embarrass the trade or traders in or around the locality in the future as held by judicial authorities, cited earlier in similar cases. Also, Shimla, Shimla is a prominent city of India and well known abroad. The goods produced by manufacturers are not prominent to the region. So this is what has happened. Now, if you come out with a matchbox saying that this is from Shimla, so people will get an idea that Shimla also produces matchboxes, which is wrong, which would basically hamper the reputation of Shimla and the people in there. So the Shimla mark was outrightly rejected again. The second case law that I have is Mount Everest Mineral Water Limited versus Bisleri International Private Limited. Now this was decided by the Intellectual Appellate Board in 2011. So again, I'll quote a paragraph from there. It says registration of the word Himalayan does not confer any right to the exclusive use of device of mountain or the word Himalayan, and that the word Himalayan shall be used only in respect of water sourced from the Himalayan water. So which means that this company, Mount Everest Mineral Water Limited, they could not have a trademark saying it as Himalaya and then selling potable water. That water is not sourced from Himalaya, and it is being processed in a machine or in a plant, in a filtering plant. Hence, you cannot have a trademark called Himalaya. The third one is a very interesting one. It comes from the court of South Africa. It took me a little while to look for it, but basically I was looking for something which would say that the manufacturers are actually deceiving the customers in saying that that what we are producing is coming out of a particular geographical region. So this is what the Supreme Court of South Africa has to say. Unless the trademark guarantees the product of a quality bound by that region will amount to deceiving the consumers. In one line, it explains it all. So I'll move on to my next slide, which is for biopiracy. Now, so this is a situation where indigenous people, TK is actually traditional knowledge. Traditional knowledge in the IP regime, we call it as TK. So, एक minute, yeah, Jay, you will have to pause. So, like I said, TK is basically traditional knowledge. Now, traditional knowledge is what has come under the purview of intellectual property. So, like I mentioned, a situation where indigenous people, TK, and their biological resources have been unlawfully or illegally utilized, usually by researchers and companies who thereafter claim intellectual property rights over products or processes. There have been situations where people have taken patents over something that was naturally in existence. I'll cover that in the next upcoming slides. Now I would want to introduce you to Mrs. Vandana Shiva. Mrs. Vandana Shiva is an activist when it comes to biopiracy. And she was the one who had defended our cases, basically of turmeric case and the basmati case, which are very prominent when it comes to biopiracy. So she had defended India, and made sure that the patents that have been filed by the US were cancelled by by the US and by the European Union, were cancelled. So she says biopiracy refers to the use of intellectual property rights to legitimize the exclusive ownership and control over biological resources and biological products and processes that have been used in centuries in non-industrial cultures. So she puts it in a very peculiar way. She says that all the biological resources and products are biopiracy. So patents claims over biodiversity and indigenous knowledge that are based on the innovation, creativity, and genius of the people of the third world are act of biopiracy. So the people of the third world who are still living in the jungles, this is where biopiracy is more prominent, because when it comes to a country like India, where we still have a legislation that protects their rights, there are other countries in the world, third world countries, who do not have any idea about their protection when it comes to biopiracy. So this is my first case, which I would want to rely upon, is the Mexican yellow beans case. Now, what had happened was that there were a few researchers who had gone to Mexico, and they had taken out the seeds, what is called as the inola seeds, from Mexican farmers. They had borrowed those seeds. They had come to America, made some adjustments to the genes so that their beans also look exactly the same yellow color as that of the Mexicans. A company, a person called Larry Proctor had acquired a US patent, not only a US patent, but also a plant variety protection certificate over the particular seed that they had made in their laboratory. Now, when they made these seeds available in the US, they started exporting it to Mexico. And the Mexican farmers, in return, were asked to pay royalty over these particular new seeds. So the Mexico farmers protested. They said that something that has been grown for over thousands of years and generations in Mexico, how can they pay a royalty over something that belongs to them? So, which is why the patent was again cancelled, and Larry Protector had to lose his rights over that particular seed that he had made in his laboratory, which was so similar to something that was already in existence. Now I'll come to my second case, that is the Brazilian berries. Now, these berries actually gave rise to what is known as the what you will call as the sugar, the processed sugar, or what you will call as the sugar free, which does not have any carbohydrates, the sugar that does not have any carbohydrates, or what is healthy people want to use. So these berries have 54 amino acid residues with no carbohydrates and is 2000 times sweeter than sugar, but it will not give you diabetes because it does not have those kind of amino acids that would actually give rise to diabetes in you. Now there were researchers. Now there was a research being done on it, and then a sweetener was produced. So this sweetener was basically used in diet cola, and there were patents being filed for it. Again, the West African world, they have protested against this patent. They said that these berries have been in are been growing in West Africa for over centuries. Again, and indigenous people already knew about it. So there was no point in getting a patent that was there in existence already. So, however, this patent was cancelled. But as we know, sugar, the what is known as this sugar is still in existence. Although there is no, the patent expired long time ago. It's in the public domain now, but this was the earlier case of how the artificial sweetener came into being. Then we have this South African Hoodia Gorodini. Uh, क्या नाम है जय जय
Yeah, Zubin.
I think ये edit करना पड़ेगा because these two slides. So, so the next case now we have is the Asian chickpea. Now, as we know, the chana, the Goreka chana over here that was already been produced here in India for over I don't know how long. Maybe when India wasn't a part of the Asian subcontinent, it's been there in production since then. It's been there and produced since then. There were some Australian, there were a few Australian agencies who had come to India, and when they looked at the properties of the chickpeas, they found that it is high in protein, and so the protein powder was thus produced in Australia since the 1990s. So once they came out with their protein powder, which was actually a crushed of just a crushed powder of these chickpeas, India once again revolted against this patent, and they made sure that this patent got cancelled. Although in Australia they were still using their protein powder, which was actually a crush of Asian chickpea, but they could never get a patent over it. So this was another case. Now we come to what is called as the Jivani case. This is a very interesting one because this is where the rights of the Biodiversity Act came into being. What is called as the benefit sharing. Benefit sharing was here introduced. Hmm. So I'll narrate the story of the Kani tribes. The expedition of scientists was accompanied by a few men of the Kani tribes and their guides. During the arduous treks across the forest, the scientists noticed that the tribals constantly ate some fruit, which kept them energetic and agile. When the exhausted scientists were offered, they also felt a sudden flush of energy and strength. When asked about the source of the fruit, however, the Kani tribals were reluctant to reveal the same, saying that it was sacred information and a tribal secret and not to be revealed to outsiders. It was after such persuasion that they showed the plant from which the fruit was obtained. They then collected some specimens of the plant to study its properties, which can be extracted by the tribals. A detailed scientific investigation of the plant was conducted, including chemical screening to isolate the active principles and pharmaceutical screening. The findings of the research can be summarized as follows. The fruit belonged to the plant taxonomically characterized, which had been documented before, but its traditional use and special properties were not known. The fruit of the plant showed anti-fatigue properties that the Kanis had identified. Study of the leaves revealed the presence of certain glycolipids and non-steroidal compounds which had anti-stress and anti-hepatotoxic properties. The last phase of the research was shifted where the drug Jivni was formulated. So this Jivni was thus formulated from these fruits and leaves that were taken from the Kani tribes. So a question remained unanswered for a long time. Who do we give the money to? To the two individuals who reveal the knowledge, or to the whole Kani community But after discussions with Malikani and Mathankani, the two Kani men who accompanied the scientists to the forest and few other community members, it was decided that it should be given to the whole community. So once you had decided that the whole benefit had to be given to the community, a whole trust was formed, and thus with this trust, the money was then given out to the other individuals of the Kani tribes. So this is how the benefit was actually shared between all. And the next we have the Neem case, which quite a lot of people know about it. It was a corporation called WR Grace who ungracefully filed for a patent application for Neem. Neem, as we know it, has been grown in India for a very long time, for over centuries again. And we all know the properties of Neem. Especially, it is a mosquito repellent, of which we have been listening to and have grown up listening to. So the corporation WR Grace filed a patent for a mosquito repellent, which was actually extracted from Neem. And this is how the Neem patent was thus cancelled. Then we have the turmeric case. Again, the same thing. We know that turmeric has healing properties, and we've been known that for a very long time. So thus, again, India stood forward and made sure that the patent over turmeric was also cancelled. And then we have the most famous case of all, the Basmati and the Texmati rice case. Basmati is grown here in India. We know the properties. We know it is a long grain rice. We know it has a particular fragrance to itself. And yet, researchers from Texas grew their own variety of rice, and then they went and got a patent over it. And they sold it in the name of Texmati. So Basmati became Texmati. It's like the Indian paratha became pizza in Italy. It's just an open paratha. So that's what basically happened there. Now I come to a very interesting topic, which is called the Traditional Knowledge Digital Library. As we know it, Ayush, uh, uh, our initiative of the government, what they want to do is they want to make a digital library wherein all these things that have been known to us for over centuries will thus be noted down in this library. So something like the properties of basmati, the properties of neem, or other plants of which we don't have any idea of as of now, but probably indigenous people do have that idea. So all those things will be noted down in this traditional library, traditional knowledge digital library. So what will happen is that if someone goes and files a patent anywhere in the world, the first thing that has to be challenged is whether if the knowledge is new or whether if it has been used for over a certain period of time. Now when things will be written down in this digital library, when you will have context of it over here in this library, the patent will outrightly be rejected. It will not even go through the scrutiny, because something that has been there, the know-how has already been there, written and published and cited. So which means that you cannot, so anywhere in the world, these problems of neem, basmati and turmeric would probably not come up anytime in the near future. Then we have conventions on the protecting the interest of the indigenous people of biodiversity, like I had said. So there's Universal Declaration on Cultural Diversity in 2001. Universal Declaration Human Rights of 1948 contains several clauses related to traditional knowledge, which include right to maintain, control, and develop cultural heritage. Then we have the Convention on Biological Diversity. The entire length and breadth of the convention is solely for the protection of the indigenous people and focus towards protection of traditional knowledge. So this is the convention that actually talks about biological diversity, not only about the people, not only about indigenous people, but also it protects the herbs, the soil, the water, everything that would come. Then in India, we have the Panchayats Extension Tool Scheduled Areas Act 1996. This legislation protects, preserves, and directs developments towards the conservation of traditional rights over natural resources of tribal societies. Then we have the Biological Diversity Act 2002. Like I said, it has the benefit sharing in it. Then it has misappropriation of biogenetic resources. That is what biopiracy basically means. And providing legal recognition and support to biodiversity and associated traditional knowledge. So this is where your library, the library that I had earlier spoken of, comes into being. Then we have the National Biodiversity Authority. This authority also is enacted under the Biological Diversity Act. It is established under Section 8, Subsection 4 of the Biological Diversity Act 2002. It advises government on matters relating to the conservation of biodiversity and biological resources. Under Section 54, oppose grants of IP on the basis of traditional knowledge. So under Section 54, you can actually oppose a patent of which there is a knowledge already known in the public domain. So that's all for today. I hope I was clear on my whatever I had to say.
Absolutely, Mr. Mehta. Thank you so much for being a part of our session today on IP laws. And it was. I'm sure it will be of great learning experience to all our viewers who are watching this segment today, especially biopiracy and geographical indications, because this is something
Indication.
totally new to all our viewers. So thank you so much, Mr. Mehta, for taking out time from your busy schedule, on a Friday afternoon. And thank you so much, everybody, for watching this. Stay tuned. The next episode, it's on its way. And till then, stay home, stay safe, and please don't forget to like, subscribe, and share my channel. That will be all for now. Thank you so much. Thank you, Mr. Mehta, once again.
Thank you. Thank you. Thank you so much.